Hi, everyone. Harry here to talk about the Florida Supreme Court abortion decision, a pretty big development in one of the biggest states in the country that always figures in deeply in the presidential election, although now has been trending pretty reliably red. Okay, it's a little bit complicated. Hang with me a bit. A couple years ago, Florida legislature passed the statute that the Supreme Court adjudicated yesterday. It's a 15-week ban, and the Florida Constitution has a privacy clause, an express privacy clause, unlike the implied privacy clause in the U.S. Constitution. Says something like government, cannot intrude on a citizen's privacy unless it can. The Florida Supreme Court had interpreted that to provide a fair bit of protection for abortions in Florida generally. In the whole sort of abortion desert of the South was a place where abortions were, relatively speaking, more available. All right, so this 15-month ban proceeds, but it gets, a suit happens and it gets put on hold while the Supreme Court is hearing Dobbs. In the meantime, about a year ago, the Florida legislature passes a 6-week ban, but it says, this will go into effect if the 15-week ban is upheld, and we'll wait to see how that plays out. So, two-part decision yesterday in the Florida Supreme Court. First and most importantly, the 15-week ban, says the Florida Supreme Court, is constitutional, notwithstanding the privacy right in the Florida Constitution. We are loosening, they didn't say just completely reading it out and saying there's no purchase for abortion at all in the Constitution. Women have no interest, but we are loosening our reading of it from what we previously said. The 15-month is okay. And note, that means going back, the 6-week ban that was passed will now go into law, but again, subject to its own challenge. Now, what would come up is the 6-week ban okay under this new thrust of jurisprudence in the Florida Supreme Court? But at the same time, a little bit wacky that they heard them together, there's a constitutional proposed initiative. It's a strongly pro-choice initiative that basically, permits abortions, and then says, in addition, it can be not just viability, but even after, depending on the situation, the medical situation of the mother and the like. The main thing is it's a pretty permissive abortion provision that would return things to as they stood under Roe v. Wade, or probably, somewhat more expansive. And the second question that the Florida Supreme Court decided is whether or not that provision could go on before the voters in November. And they held that it could. 3 justices, all women as it happens, voted that it shouldn't go because it's just too confusing. We're not exactly sure what it means, and it doesn't pass muster for sort of minimal clarity in order to go on the ballot, but it went on the ballot. So where are we in Florida? We have the 18-month ban now upheld. And that means that a 6-month ban has been passed, but not yet upheld. But we have an initiative on the ballot for November that would be much more strongly pro-choice. And this is Florida. So that means, for starters, it's going to be a total hotbed of political activity and money, commercials, and the like, all dovetailing with the presidential election. In general, abortion has played to the benefit of Democrats in the last few years, and so that creates some headaches here for Trump. I don't think many people would say enough headaches to switch the state over, but it will require the Republicans to play defense in Florida. It'll just be a very, very expensive time. And there are office holders there, Republican office holders like Rick Scott, who, if there is a general turnout and a general vote in favor of the pro-choice position, that, at least in Florida, it more likely aligns with Democrat than Republican voters. That could be a threat to guys like Rick Scott. It's going to affect the dynamic of one of the most closely watched states that has in the past given us a lot of kinds of crazy developments. Is no longer considered one of the sort of 6 or 7 swing states at the epicenter of the election, but it's remains important, and this will change the whole dynamic. Okay, so legally, the big point legally is, here we go. The Florida Supreme Court, the Constitution didn't change, just like the Constitution didn't change since Roe v. Wade was decided. But all of a sudden, the Florida Supreme Court, heavily focused on the U.S. Supreme Court and its Dobbs decision, says, oh, you know what we were saying before about abortion and the express right to privacy in the Florida Constitution? Nah, we were just a little bit too strict there. We're changing our tune. So all the controversy that engendered on a national level happens now in Florida, but with the additional complication of the political initiative that would make things far more permissive in Florida. And then, put on top of that the presidential election, the money, the general dynamic that abortion has been playing in the last few terms, and you get some pretty big political, legal, and individual rights news. So that's the story from Florida as of April 1st, even April 2nd, and to be very closely, I think, monitored all the way for the next 7 months to the election. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.